the work that you have done, and the advocacy that you've done, and how much we appreciate the city, all the work that you've put into this, and Shannon Baltazar as well. It's really helped us. And you certainly are a very strong advocate, and we appreciate that. So thank you, everybody, and welcome and good morning. As Ryan said, my name is Jim Lopez. Please call me Jim. I am a deputy city manager, and my purview is external affairs, and working on the tenant protection legislation was one of my, and continues to be a project of mine. And I really appreciate the opportunity to talk to you and really educate you and everyone about the changes to the law. What I'd like to do, Ryan, is I have a PowerPoint. I'd like to share my screen. I'll work through the PowerPoint and we'll save some time. I know we only have a half an hour for questions. I do want everyone to know there's contact information in my presentation, and this is an ongoing conversation for sure. So please feel free to follow up on any of the numbers, and even to me directly after the presentation, or through Ryan, if that's okay with you, Ryan. So can everyone see my screen? Is that a thumbs up?
Your screen.
Okay, great. So
Jim, real quick, we had a question. I just want to get this out of the way. This will be recorded. We will be linking it on our advocacy news site, and we will send out a follow-up email with that link.
Thank you.
Sorry, James, go ahead.
So the tenant protection. So here's the presentation on tenant protections. What I'm going to do is just break it up into kind of 4 sections. We'll give you a little background on the legislation. We'll talk about the key provisions of the legislation, which I'm sure everybody wants to know about or more about. I'll talk a little bit about the frequently asked questions. We're building a database of them. We're posting it right on the website. It's very easy to get to our website. You just go to the city homepage, you type in tenant protections. It will take you to really what you need to know. We're compiling all the history and FAQs, and then we'll talk through some questions in the time that we have left. If I can't answer any questions, I'll do my best to get back to you and put it on the FAQs. So on August 3rd, the council adopted this legislation. It's 04810. It was based on the ARCH recommendations. You may be familiar with the ARCH recommendations. Other cities have been adopting them. They're very similar to what's going on in Seattle. And it comes after focused engagement. We did, in a short period of time, we did do a lot of engagement with both landlord groups and tenant groups, and we really trying to manage the interests of both of these groups, and discovering, frankly, that there's an enormous amount of common ground and common interests. And we want to keep our work going at the city of Kirkland to rise to meet those common interests and improve the landlord-tenant relationship and just the supply of housing generally. This is really a common goal and a high priority for the city. And in that spirit, this is very much part of a larger initiative around tenant protections, not just fairness for landlords and tenants, but also very much to engage in conversations about increasing the supply of affordable housing in our city and in our state. So here's a quick timeline of events. This came to the council on May 3rd. They provided staff with direction to go back into the community. We did expeditiously, coming back on July 5th. We got a chance to speak to a lot of groups, and very grateful to how organizations like Ryan's and others organized so quickly and provided so much information. And in the information that was provided, there's a huge database of it in the council packet. So if you go to the July 5th council meeting and you click on that packet, you'll see my memorandum and all of it. I really tried to database everything that we received, and all of that information. It actually may be in the August 3rd one as well. So there's a lot of information for you to see. So let's talk about the key provisions. First, there are 2 essential changes, 2 key changes to existing landlord-tenant law. First is notice of rent increases for 180 days, 6 months or more. If you're going to increase rent by more than 10%, I'm sorry, if you're going to increase rent by more than 10%, that 180 days is now the required notice period. So you have to give that amount of notice to increase by 10%. For 3 to 10%, it goes to 120 days, 4 months for proper notice, and the existing state law for up to 3%. So this is the difference. It is very similar to other jurisdictions in terms of notice. The other key provision is the maximum security deposit. Here, the maximum amount for move-in fees and security deposits. And we had a question about this. Does this preclude pet deposits? Our interpretation is no, it's just part of the maximum amount, and other special move-in expenses is 1 month's rent total. Again, that's very similar to other jurisdictions. There are a couple of more specific details. For example, tenants entering into rental agreements lasting 6 months or 6 or more months may choose to pay their move-in fees and security deposits in 6 equal installments over the first 6 months in the dwelling unit. It is right in the legislation, and of course, the legislation is right on our website. Tenants entering into agreements lasting fewer than 6 months or month-to-month agreements may pay move-in fees and security deposits in 2 equal monthly installments. So that's part of the change. There are exceptions to this. The move-in fees and security deposit provision can be waived if certain criteria are met. This involves a little bit more detail, and it involves an agreement, and I'll read from the statute, the ordinance. A landlord and tenant may agree in writing to waive specific requirements of this chapter regarding the limitations of a landlord can require relating to move-in fees and security deposits. If all of the following conditions are met, and essentially the agreement to waive specific provisions is in writing and identifies the specific provisions to be waived. 2, the agreement may not appear in a standard form written lease or rental agreement. And 3, an attorney for the tenant has approved in writing the agreement as complying with subsections B1 and B2. So it's really kind of a, in those instances with representation. And we had a lot of discussion about risk mitigation for landlords and landlords who want to provide tenants that might not otherwise qualify with higher security deposits because they want to mitigate risk, but they also want to give the rental. Some other avenues to do that. And this provision, section 775055, is something that does that. So for those of you that are interested in that, please go to the resolution and you can see it right there. So let's talk about some frequently asked questions. When does the ordinance go into effect is usually the first first question we get, and that would be September 17th. So thank you very much, Ryan, for putting this together in short notice. It's good to get the notice out there. Lawful rent increases issued prior to September 17th in the city of Kirkland are valid, and further notice is not required. So this is the time period leading up to the effective date of the notice, and it is not effective until that date. Another question we got is, what about provisions regarding move-in fees, security deposits in existing rental agreements? And here, the legislation makes clear that provisions regarding move-in fees and security deposits that are in existing rental agreements are valid until the original rental agreement expires. So there's not going to be exchanges back and forth of security deposits during the term of existing documents. Rental agreements makes the transition much easier. How will the ordinance be enforced? This is a popular question. There is no other specific enforcement provision in the Kirkland legislation. I believe there are these types of provisions in other legislations. Our review of this is that tenants can enforce the provisions of this ordinance in court. It is a right, most likely in small claims court or a similar venue, to enforce the provisions of the ordinance. So you have to comply. Are there any exceptions to the notice of rent increases in the provisions? There are exceptions for certain types of subsidized housing where rents are based on the tenant's income. This is very common and makes perfect sense for the types of subsidized base incomes in terms of the notice where it's based on the tenant's income itself. How will the city evaluate the effectiveness of the regulations over time? Well, the intent really is to balance the interests of landlords and tenants, and we're going to continue to review and evaluate to see how it's working. We're going to listen to folks like you and Ryan and others and tenants and tenant groups, and we're really going to try to find that common ground of fairness and notice, but also allowing our landlords to effectively manage their assets in a way that is conducive to increasing housing supply, which we know we desperately need. So there's a balancing of interests, and the city is very interested in devoting resources to making sure that we monitor how this goes and whether or not we're seeing that balance of interests. Very importantly, here's our contact information. You go to the tenant protection page on the website, like I said, and there is a number to call. If you want to speak to somebody, you'll go to the planning department. The planning division has a number posted. You can also send comments through the website. And you could send comments to the city's Our Kirkland system as well. So there's a lot of ways, both in person and via the email system, for you to give us feedback and let us know how we're doing. And of course, Ryan and I are going to keep working together, and we can keep that conversation going through Ryan's organization as well. So that is a quick overview of the city's landlord tenant or the tenant protections ordinance. And Ryan, with 15 minutes left in the presentation, I think we're on schedule to take questions. Yep. And discuss any detail and further.
So everyone, thank you, Jim, for that. I'm assuming one of the main reasons we want to have this webinar, because I know a lot of people have questions, I would encourage you to type up a question in the question and answer button. If you can see it, it says Q&A with little thought bubbles down in the bottom of your panel, and then we'll get to them, and I'll try to get as many of them done as we can. So a question I have for you, Jim, I'm going to read these out loud in case people don't want to go into the chat button. When you went in the community to work with landlord and tenants, what were the key parameters did you use to come to your determination?
Well, the conversation was framed by the recommendations from Arch, and there were 3 recommendations from the Arch proposal for Kirkland. And the 2 of the 3 we adopted, as I just went over. There was another recommendation that involved the limiting late fees that could be charged. So when this very specific outreach was designed around discussions around the interests behind those 3 proposals. We did get a lot of comment and discussion about other issues. We especially got other ideas from the landlord association, the associations representing the landlords. So there are a lot of other ideas out there, but this particular initiative focused on those 3 Arch recommendations.
Great. I have another one, and I think I know the answer after reading the ordinance enough times. But so, Jim, in regards to payment plan option for deposits, are we required to offer that or feature it in marketing material, or do we just have to honor it if asked?
I believe it is. I believe you have to honor it if asked. Let me just, if you go to the provision itself, it does allow for that. Tenants may choose, so it is their option.
Okay. Yeah, I didn't see anywhere there was a requirement you had to advertise it, but
no, not. I don't know about that. I do know that the tenants do have the right to choose.
Yep. So I have a question here, and I might reframe it from Cassandra. She said, detail I missed. Can you review once more how pet fees cost deposits are or are not part of the 1-month limitation on moving costs? Basically, the way I read it, all fees, including pet deposits, are part of that. Are they all part of that one total? They can't be more than 1 month's rent? Or is there
That's our interpretation of it, yep.
No, so basically, there's no exclusion for pet deposit or any other type of fee to allow that to go over 1 month's rent.
No, that's not our understanding. It's a great question, though.
Okay, I think we've answered that a couple times. We had a few people ask that question. I'm not sure what the question exactly is here, though. Will there be a legal addendum for the deposit agreement? I would not say that's part of the ordinance. That would be an internal process for management, right?
Yeah, I'm not sure I understand the question. I think we did get a lot of, we got some interesting thoughts on the city taking a role in standardizing forms in Kirkland, you know, to make sure that it's easy and streamlined for landlords to comply. So we're giving a lot of thought to that. I'm not exactly sure. I'm not aware of any necessary addendums. I think it's supposed to fit into the current structure of your security deposit and how you do them and the way you give notice, your forms.
And David, if you want to follow with me separately, we can research that more.
Sure.
If you have more specifics. I do have a question as well, Jim. I think I've highlighted before. I've had a few people not in this jurisdiction, others ask, well, what if we have a graduated increase in rent? How does that deal with the notice? Because I've had a few people say, well, working as we're raising rent, we work with our tenants sometimes to graduate, you know, to get to a higher, that's probably going to go over that 3% or whatever the case may be. How does that work? Or is that even contemplated in the ordinance?
Well, yeah, I mean, I think it really depends. You go to the letter of the ordinance, it's by the term of the agreement. So I think you just have to, I mean, are you talking about crafting it in an agreement itself that escalates over multiple years?
That was the question I've received.
Yeah, I mean, I think I think the best I can do is just say, read the letter of the law, basically, which is the term of the agreement. But, you know, I would say you probably just have to look at it on a case-by-case basis to see that it is in fact an authentic agreement and then see if it's violating the spirit of the law. But I would say, you know, if it's a legitimate agreement, the argument can be made that you're operating within inside the four corners of your agreement. I would just be mindful of making sure. And it's really, Ryan, the best I think you could do is look at it on a case-by-case.
Okay. Oh, and David, thank you for requalifying your question about the legal addendum. You're referring to the NAA lease forms. Yeah, I'm assuming some of those may be updated, but I know NAA just updated those forms that are on our site for some Seattle stuff that recently changed. I think there's a little bit of a lag there. I wish I could give you an answer of how quickly those will be updated, but they should be updated across these different jurisdictions. Oh, very good question, Jalen. If we want to increase the amount within the notice period, do we need to resend and start over the 120, 180 day period?
Could you say that again?
If we want to reduce the increase amount within the notice period, do we need to resend and start over the 120, 100 day period? So I'm assuming, say you've made notice, you actually don't want to do 6%, you want to do 5%, you're not going to have to comply directly, you're not going to have to go and redo that and push that 120 days back again, are you?
Well, yeah, I mean, it doesn't appear that way because we're talking about increases in rent. So if you've given notice of the increase compliant with the ordinance for the amount and the amount goes down, I think it sounds to me like you would be compliant. I think that's a reasonable interpretation. If you want, I can certainly research it further, but it seems like common sense would say you've given your proper notice and that a lower amount should be fine.
We have another question here, and I can answer this one. Are these laws statewide? No, this is only within the city limits of Kirkland. We have similar proposals in other cities, including Redmond has already passed theirs, Kenmore, a couple others, Issaquah just passed a notice requirement as well. To that point, if you want to see those, if you go to the WMFHA.org page, there's an advocacy button. Look under advocacy news. I post these as soon as we get them confirmed from the city. So that's a kind of a good clearinghouse for you to find these. But no, these are not currently at statewide. These are only contained with local jurisdictions.
Thank you for that, Ryan.
Any other questions? Will you revisit late fee restrictions? There are no late fee restrictions in Kirkland. I can answer.
There are none. I can't say that I'm not aware of anything on a future agenda.
Yep.
Whoever's asking the question, but you could stay close with Ryan if the council takes it up. Yeah, it's a great question.
Yeah, I could speak to that. I think Jim was referring to the ARCH proposals, how we got to where we're at. There were multiple proposals and Kirkland did not adopt all of them. One of the ones that Kirkland chose not to adopt was a late fee restrictions. Okay, here's a question. Is the 120-day or 180-day notice based on gross increase or just increase of base rent? If example, here's the nuance is, if someone received a 1 month free concession, is that taken into consideration?
If somebody received a
1 month free consideration, so they've got a 1 month rent free. I know how I read the law, but
yeah, I mean, the plain reading of the law is as I just read it, notices of rent increases. I think if you want to, it might be helpful if you write some of those things up. I could run it through our internal team and maybe post it as an FAQ. We could talk maybe different scenarios about rent reduction and things like that. But I think the interpretation is what your rent is in its most basic form, and then what the increase is of that.
So, and to that question that Janet just posed, I know it. I get where the crux is there. So, Jim, if you want, we can work together on that, and I can kind of maybe work that example out with you. We can get down the frequently asked questions, and I can include it maybe in one of my update posts or something like that. So, everybody.
I think that's the best way to do it. It's a very good question.
Do we have any more questions? Well, we have. Let's see. Just a statement, Shaylin. Yes, you can submit one-offs to me, as well as Jim pointed out. You can send them directly to to him and his team over there. It's really valuable for them because they're the ultimate arbiters of the law, and they can probably give a better answer. But it will also allow them to post it so others understand as well. But I don't mind being a conduit for that as well. Obviously, Jim and I work really closely together. I think we've been on the phone every day for the last 2 days. So that we can definitely take care of that. And to that point, before I thank everybody for coming and maybe give you a little bit of your time back, Jim, did you want to give people an idea of what you're working on as well? I know there's a mitigation fund that you're considering, and I think some people might be interested in what's going on there.
Yeah, the council gave us direction to explore what we're calling a landlord tenant risk mitigation fund, where we're putting together a pool of money that would help landlords and tenants achieve residencies where otherwise tenants might be reticent to give them because of certain risk factors. We understand you have a business and you have to make sure your business meets your risk management parameters. Ryan has actually offered, and I really appreciate, to help in this work, and we've certainly are eager to do that. The idea is, what would be the best criteria to design a fund that would enable them? We're thinking most specifically about the security deposit element of this. If somebody comes to you who you feel would be a good tenant, but otherwise doesn't meet perhaps credit requirements, maybe has a recent bankruptcy, there are other things that raise some concerns in your risk mitigation profile. How can the city help with a fund to proactively create some security there? And we have some ideas about how that might work, and how, and what Ryan and I have been talking about and others is really providing a strong incentive for the tenant to stay in compliant with the lease in a way that rewards both the tenant with the funding, but also certainly rewards the landlord with the security during the tenancy. That's the key. So yes, we're working on that. If you have ideas, if you have thoughts, knowing that that's what the city's goal is, please send them to me, send them to Ryan. We know the answers in the room with you all. You are doing the work. So getting insight into real world examples would be very helpful for us.
Great. Well, I could give everybody 1 minute back by the time I'm done speaking. But once again, thank you everybody for joining us today. This has been recorded. I think I missed my first introduction for that recording. I was a little slow on the button. However, this will be recorded. We're probably going to clean it up first a little bit, edit it for the front and back end, and we will get it posted. Once that's posted, we'll send it out to everybody that provided their email when they registered. Thank you everybody for coming. I have a hand up, but please, Irma, if you have a quick question, if you want to throw that in the chat, please do it that way. But thank you everybody for coming. We encourage you to go to the website to get more information there. Like I said, we include information about these kind of things across jurisdictions in the advocacy news tab, as well as if you are in our database for a certain jurisdiction. I also usually send emails out highlighting your opportunity to testify on these issues, as well as if they do pass, what they are and what you need to comply with. We will work with other jurisdictions as we move forward, as long as their staff is accommodating as Jim. Try to put more of these on when these ordinances are passed, so you guys can get to know what you need to comply with. And
thank you to everybody, Ryan. Thank you to you, and thank you to all of the participants. We really appreciate you coming and asking questions, and look forward to working with you.
And real quick, I will answer this question, try to get you out a minute early. That question for Irma was, when you said move-in fees, that include application fee and admin fee. All move-in fees, well, I'll let Jim answer that.
Yeah, my understanding is your move-in fees are included in the 1 month, but please write it up. We'll review it and post it on our FAQ.
Yeah. Thank you, everyone. Have a wonderful day.